Swayam Prabha. Digital India. Educated India.
Hello friends, in the present session I am with you with the topic Dowry Prohibition Laws as lecture number 14 to the course Law relating to women and children. In the present session I will discuss the law relating to the dowry prohibition. We all are aware about the bias, the menace of the dowry. This is the offense or this is the crime. This is the ill practice in Indian society which gives rise to certain other crimes, to certain other offenses also. Dowry is not limited, or this offense of dowry is not limited only to be committed during the marriages, but it gives rise to other certain offenses which are very detrimental to the rights and dignity of the woman. And therefore, it becomes relevant to discuss the law relating to dowry whenever we make the discussion over the laws protecting the women and children also. Because the mental status of women, physical strength of women, the educational strength or educational qualifications of a woman, the social and psychological status of women is directly responsible for the care, the growth, the development and education of children. And therefore, the law relating to women and the law relating to children, these are two integrated laws. These cannot be separated from each other. Without taking consideration to the laws relating to women, we cannot ensure the protection of the rights of children. With this point of view, this course law relating to women and children was designed. Under this present lecture number 14, we are discussing the dowry prohibition laws or the laws relating to the dowry. I was telling you that the vice of dowry or this social practice of dowry gives rise to certain other offenses. What are those offenses which are the result or consequence of the dowry? Always we talk about the female feticide, and this female feticide is considered to be the greatest offense on the earth against women. When the girl child is murdered in the form of fetus itself. How the parents they take the decision, what is their mental, psychological, sensual, emotional conditions in which they are prepared to make the offense of female feticide. The main cause behind this female feticide is the offense of dowry or the demands of dowry when the parents are going to marry their daughters. And therefore, to get rid of this big challenge in future, they make this offence, this crime of female feticide. The offence or the crime or this ill practice of dowry is also responsible for domestic violence against women. We know the instances in the society, in families, where the women are very ill treated, who come without consideration of the marriage in the form of dowry. They are always threatened by the in-laws to fulfill the demand of dowry. Sometimes we see that dowry deaths are caused. So it gives rise to the murder of a married woman in the form of dowry death. It also gives rise to the domestic violence against women, which causes the mental threat, the psychological impairment, the physical brutalities against women, and they bear these things lifelong, and therefore the dowry is such an offence which must be eradicated, which must be curbed, which must be dealt with very stringent, effective and strong legislative initiatives. In this background, we are to discuss with the dowry provision laws or the laws relating to dowry in India. If we look at the dowry system in India, first we are to see the meaning of the term dowry or how this practice came into existence. This practice is not limited only to Indian territory. In Arabic, dowry is referred to Dahej. Dahej is very popular name of nomenclature of dowry, popular synonym of dowry which we use even in India. But this Dahej is the Arabic term of dowry. It means that in the area of Arabs or in Arab countries, dowry was also in existence. In the eastern part of India, it is known as Anupad. Dowry in the modern Indian context is referred to giving valuable property to the bridegroom, his family, relatives, by the bride's parents as a condition of marriage. Now this has become the practice that when the father of the daughter, the family of the daughter, goes to the family of the bridegroom, for possible marriage or prospective marriage, then certain conditions are laid down. Though in India the marriage was considered to be, still it is considered under Hindu law as the sacrament, not the contract. But if you see the initiation of the process of marriage, then within the negotiations between the families, two families, the bride's family and bridegroom's family, certain conditions are laid down for the marriage. The considerations are set out for the marriage, that what kind of articles, items, gifts would be presented in return of this marriage or as consideration of this marriage. What cash amount would be delivered to the bridegroom family, and which particular vehicle in the form of cars, etc., would be gifted to the bridegroom. So all the conditions are set out. This is the modern practice of dowry. The practice of dowry became a social evil in modern India and became cause of exploitation of women in different parts of the country. NCRB data shows that as many as 13,534 cases were registered in the country under the Dowry Prohibition Act 1961 in the year 2021. It is a 25% increase in the number since the last year, that is 2020. So, in a year 25% cases of dowry increased. Despite the different regulatory measures, different legislative initiatives, social initiatives, educational initiatives to curb, to eradicate the vice of dowry. The reported dowry death cases amounted to nearly 6.8 thousand in 2021. This is the data of, this is the number of the dowry deaths, where the women, they got dead, they were murdered, or they made the suicides because of the demand of dowries or because of their exploitation for the dowries. There is a gradual decrease from the year of 2014, when the number was approximately 8.5 thousand. So, it is the matter of fortunate, matter of happiness, the matter of pleasure, that from 2014 the number of dowry that is being decreased, but this decrease seems to be nominal, not very material. From 8.5 thousands, it decreased to 6.8 thousands. Their anti-dowry laws, if we talk about the anti-dowry laws in India, because we are dealing with or we are discussing the dowry prohibition laws. Dowry prohibition laws means anti-dowry laws, or the laws which have been enacted to deal with the ill practice of, social evil of dowry. There started anti-dowry movements in pre and post independent India during the English rule. We know that two important social movements which started, these were for the concerns of widows, for widow remarriage, and for the prohibition of dowries. After independence, the Dowry Prohibition Act 1961 was passed as the consequence of, or as the result of, the social awareness and social movements in pre-dependent India, and also the voices which were raised in the post-independent India. In the year of 1961, the Dowry Prohibition Act was passed, and it declared the dowry as an offence, and this offence of dowry was prohibited under the act by stating that taking or giving of the dowry is an offence. It reflected the anxiety of the government to deal formally with the menace of dowry and to curb the offences for which the root cause is dowry. So, when we are to go to deal with the offence of dowry, it does not deal with only the offence of dowry, it also deals with the certain other offences which are responsible, which are the consequence of, or which are the result of the dowry. This enactment, the Dowry Prohibition Act 1961, it defines dowry as property or valuable security given or agreed to be given either directly or indirectly under section 2. Any consideration of the marriage or any valuable security in return to the marriage, agreement of the marriage, the consideration may be given directly or indirectly. So, the legislature included both the incidences, whether it is the giving of any valuable security directly or indirectly, even the agreement to give. If two parties are agreed to give or take any valuable consideration or valuable security directly or indirectly, then under section 2 it would amount to be dowry. It defines dowry as property or valuable security given or agreed to be given either directly or indirectly by one party to a marriage to the other party to the marriage. Not only the offer or the agreement from the side of the bride's family, even if the bridegroom's family offers or gives any such valuable consideration or security, it would amount to be dowry, because by one party to the marriage, either it is the bride's family or it is the bridegroom's family, by one or the other party, by one party to the marriage to the other party to the marriage, or by the parents of either party to the marriage, or by any other person. So, if it is directly by the parties to the marriage, or it is by the parents of the parties, or even if such valuable security is given or it is agreed to be given by any other person to either party to the marriage or to any other person. This is very important to be understood, that dowry is not the amount or the consideration or the valuable security which is given or agreed to be given by one party of the marriage to the other party of the marriage. It also includes the consideration or the valuable security or the amount or the gifts which are given or which are agreed to be given by the parents of one party of the marriage to the parents of the other party of the marriage. It would also be the dowry if any other person other than the parties to the marriage or the parents of the parties to the marriage, if even any other person gives or agrees to give any valuable security or the consideration or the amount or the gifts to the party of the marriage, to the parents of the party of the marriage, or even to any other person, then directly or indirectly, then it would amount to be dowry in accordance with the section 2 of Dowry Prohibition Act 1961. Again see, at or before, in connection with the marriage of the said parties. Originally in 1961 enactment, this was at or before, but during the amendments or by way of amendments made in the Act in 1986, one more phrase has been added, or any time after the marriage. So, the consideration or the valuable security which is given or agreed to be given at the time of marriage is not considered to be the dowry, but it also includes any such valuable security or the consideration or the amount which is given or to be or agreed to be given even any time after the marriage in connection with the marriage of the said parties. If any such amount is given, then it would also be the dowry. It does not include dower or mahr in the case of persons to whom the Muslim personal law applies. We know under Muslim personal law, the marriage is not considered to be sacrament. The marriage is considered to be the contract, and we also know the fact that no contract may be without the consideration. The consideration is an important essential element of any contract. Dower or mahr, it is the consideration of the contract of the marriage under Muslim personal law, and therefore, this is not applicable to the dower, or dower is not included within the meaning of dowry under 1961 Dowry Prohibition Act. It does not apply to dower or mahr. Under 1961 Act, taking and giving of dowry is prohibited. since 1st July 1961. The Act was enforced at 1st July 1961, and from that date the taking of dowry and the giving of dowry is prohibited. After the commencement of Act, according to section 3 of Dowry Prohibition Act, after the commencement of the Act, any person who gives or takes or abates the giving or taking of dowry shall be punishable with imprisonment for a term which shall not be less than 5 years, and with fine which shall not be less than 15,000 rupees or the amount of the value of such dowry, whichever is more. Now see that any person who gives the dowry, who takes the dowry, or who abates the giving or taking of dowry is the unique feature of this section. Because we see in marriages, sometimes the dowry is not taken or it is not given directly. In each and every marriage, always there are some middlemen who helps in the negotiation between the two parties to the marriage or between the parents to the parties to the marriage. These middlemen are called as mediator. So, sometimes we see the instances where the dowry is not taken directly, dowry is not given directly by the parties to the marriage or the parents to the parties of the marriage, but all the arrangements of the dowries are made on behalf of the parties, on behalf of the parents, by these middlemen, by these mediators of the marriage. And therefore, sometimes we also see that though the parties are not willing to take the dowry to such an extent, but the middlemen or the mediators of the marriage, they abates the dowry, the taking or giving of dowry. And therefore, all the three categories of the persons involved, the person who takes dowry, the person who gives dowry, the number one, the parties to the marriage, taking or giving the dowry by the parties to the marriage. Number two, the taking or giving of dowry by the parents of the parties, or any person who gives or takes or abates the person, any person who takes the dowry, any person who gives the dowry, any person who abates the dowry, that is the middleman, shall be punishable with imprisonment for a term which shall not be less than 5 years. We can understand the grave nature of this offence. The minimum punishment, normally we see that in offences, the maximum punishment is fixed and minimum is not. But when the offence is considered to be very grave, heinous, then the minimum punishment is always fixed. For the giving or taking of dowry or abatement of the dowry, the minimum punishment of the imprisonment of 5 years has been fixed. The fine has also been included. The amount of fine has been specified as rupees 15,000, or it is equal to the amount of the value of the dowry. And it has also been provided that the fine would be whichever is more, either it is 15,000 rupees or it is the value of the dowry. In certain cases, the punishment of imprisonment may be less than 5 years, but there must be adequate and special reasons for the reduction of the punishment from its minimum limit. And the courts and judges are to provide for, to specify those adequate and special reasons. The amendments in 1984 provides for no punishment for presents to bride and bridegroom at the time of marriage without demand. List of presents be maintained. This relaxation was made. that if any presents are given to the bride and bridegroom at the time of marriage, because this has been the practice, social practice. Even today we see, whenever we go to the marriage of any girl or from the side of the family of the bride, then we always give the some gift in accordance to our economic capacity and in accordance with the relationship with the family. We always give some gift to the bride. Similarly, now the social structure or the manner of the solemnization of the marriage is changed. So, we also give the presents or the gifts to the bridegroom, and certainly it is logical that these gifts being present by family members or the gifts being present by the relatives or friends should not be included within the meaning of dowry. Otherwise, the brides and bridegrooms would be deprived of such affectionate gifts and presents, and therefore, in 1984 amendment, this relaxation was made, and such gifts which are being offered, which are being given by the family members, by the friends, by relatives of the bride and bridegroom family, if these gifts are given to bride and bridegrooms, these are not included within the meaning of dowry. But one condition has been imposed for the relaxation, for this exemption, that a proper list shall be prepared of these gifts or presents being given at the time of marriage. It is also relaxed that customary presents within financial limits. There are certain customary presents. For example, we can see if any Hindu marriage is solemnized, then there are certain ceremonies in the marriage, and Kanyadan is one of those ceremonies. At the time of Kanyadan, the relatives, close relatives of the family or family members, they present some gift to the bride in the form of Kanyadan. So, this is also exempted from the meaning, excluded from the meaning of the term dowry. Section 4 imposes the penalty for demanding dowry, and it states that if any person demands directly or indirectly from the parents or other relatives or guardian of a bride or bridegroom any dowry, he shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 2 years, and with fine which may extend to 10,000 rupees less than 6 months. The punishment less than 6 months may also be awarded if the adequate and special reasons are there in that case. According to the proviso of section 4, the relaxation may be given, the punishment may be reduced, but only for the special and adequate reasons. Agreement and advertisements. If any agreements are made for giving or taking of dowry, or any such advertisements are made for giving or taking of dowry, these are also dealt with by the provisions of the enactment. Section 5 of the enactment declares the agreements for giving or taking dowry as void, and these enactments, when are declared as void, are not enforceable under the Indian Contract Act 1872. We know that under the Indian Contract Act 1872, only the valid agreement are enforceable. So, no party to the marriage can enforce the agreement made for giving or taking of dowry, because by virtue of section 5 of 1961 Dowry Prohibition Act, such an agreement has been declared as void. Section 4A of the enactment, which has been included by way of amendment in the Act in 1986, imposes the ban on advertisements. It is provided that the advertisement of offers of dowry in the form of share in property shall not be made. Advertisement of offers of dowry in the form of share in property shall not be made, and it shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 5 years, meaning thereby from 6 months to 5 years punishment is prescribed, or fine which may extend to 15,000 rupees. So, maximum fine of maximum 15,000 rupees, and the imprisonment, the punishment of imprisonment from 6 months to 5 years has been prescribed if any such advertisements are made to make the offer of dowry. Again, the proviso to section 4A prescribes that this punishment may be less than 6 months for adequate and special reasons. Transfer of dowry. Section 6 provides for the transfer of dowry. Dowry for the benefit of wife or her heirs. When dowry is received by any person other than the concerned woman, that person shall transfer it to the woman. Sometimes it may happen that the amount of dowry, the gifts of dowry, the consideration of dowry has been received by a middleman, by a person from the bride's family, but it was not transferred to the woman concerned. It has been, the provision has been made for the transfer of such dowry if such a dowry is made. Now, there may be the confusion in the minds that when the dowry is prohibited, then why the provision for transfer of dowry has been made? Though the taking of dowry, giving out dowry, agreement for dowry, advertisement of dowry, it has been prohibited, but if the incidence of taking of dowry has happened, then recovery of that amount which is in possession of any middleman, any other person, is also required to be recovered. The recovery is also important or significant, so that that amount may not be retained by that person. So, when dowry is received by any person other than the concerned woman, that person shall transfer it to the woman if the dowry was received before marriage within 3 months. At the time of marriage, then within the 3 months of the marriage, this shall be transferred to the woman concerned. If the dowry was received at the time of or after the marriage, within 3 months after the date of its receipt. If the dowry was received when the woman was a minor, within 3 months after she has attained the age of 18 years, and pending such transfer shall hold in trust for the benefit of the woman. If persons fails to transfer any such property within the time limit specified, therefore, he shall be punishable. If such a transfer does not take place within the time limit prescribed under section 6, then the punishment has also been prescribed with imprisonment from 6 months to 2 years, with fine which from 5,000 rupees to 10,000 rupees, or with both. So, the punishment has been prescribed, the imprisonment from 6 months to 2 years, and the fine of 5,000 rupees to 10,000 rupees, or with both. If the woman who is authorized to receive such transfer of property dies before receiving it, the inheritors of such woman are entitled to claim the transfer of property to them from the person holding such property. It is provided that if such woman dies within 7 years of her marriage and the cause of the death is not the natural one, such property shall be transferred to her parents if she has no children. This is the proviso to section 3, subsection 6, subsection 3. In section 304B of IPC, the offence of dowry death was provided. So, if any woman is died within the 7 years of the marriage and the cause of the death is not natural cause, then such a death is considered to be dowry death. And in the event of dowry death, the property or the amount of dowry cannot be transferred to the survivors of the woman or the family members of the woman to which the woman was married, but it should be transferred to the parents of the woman. And if she has children, the property shall be transferred to the children. So, it will be transferred either to the parents if she does not have any children, and if she has the children, then that property shall be transferred to the children of that deceased woman. If a person is convicted under section 6 subsection 2 for his failure to transfer the property and has not transferred property to woman or her heirs or her parents or her children, the court is to direct such person by an order in writing to transfer the property to the concerned woman or her heirs or her parents or her children. The court may make the order, and if such person does not comply with the direction of the court to transfer the property within the time limit prescribed in the direction, then recovery of the amount equal to the value of property may be made from such person, treating as the fine imposed by the court to be paid to such woman or her heirs or parents or children. In such a way, by these provisions of section 6, it is ensured that no person can hold the property or the amount of dowry which is given in any marriage. Cognizance and burden of proof in matters of the offence of dowry. Section 7 provides for the cognizance of the offence. The metropolitan magistrate is authorized to take the cognizance, or the judicial magistrate of the first class. So, metropolitan magistrate or the judicial magistrate of the first class is to take the cognizance of the offence of dowry. Court shall take cognizance of an offence on its own knowledge. It is not necessary that first the complaint is made, only then the cognizance of the offence of dowry can be taken by the magistrate. Magistrate can take the cognizance of the offence of dowry on his own accord, on the basis of the police report of the facts which constitute such offence, or on the basis of the complaint by the person aggrieved, by parent or other relatives, by any recognized welfare institution. So, the cognizance of the offence, very comprehensive provision has been laid down, that the cognizance of the offence can be taken by the metropolitan magistrate, or the magistrate of first class can take the cognizance of the offence of dowry on his own accord, on his own initiative suo motu, or on the basis of the police report, or on the basis of the complaint, and that complaint can be filed by the person aggrieved or by the parent or other relatives of that aggrieved person, or even by any recognized welfare institution. There is social stigma that generally the women or the relatives of women, they are not ready to file the complaints, and therefore, any recognized welfare institution can cause the complaint and the cognizance of this offence of dowry may be taken. The offence of dowry has been declared to be cognizable, non-bailable. It was made non-bailable in 1984. It is also non-compoundable. Under section 8, the nature of offence has been described, and according to the nature of the offence prescribed in section 8, the offence is cognizable, the offence is non-bailable, and offence is non-compoundable. We can again understand the serious nature of this offence. The legislature treated it as cognizable, non-bailable, and non-compoundable. If we talk about the burden of proof in the matters of dowry, the burden of proof is on the person who is prosecuted for taking and demanding dowry. Under section 8A, the burden of proof has been imposed on the shoulders of that person who is prosecuted for taking and demanding the dowry. Dowry provision officers and advisory board of the 5 social welfare workers, including 2 women, section 8B, provides for dowry provision officers and advisory board of 5 social welfare workers, including 2 women. In 2003, the state of Bihar enacted the dowry provision rules 2003. What are the other relevant laws in relation to the dowry? Section 498A of Indian Penal Code. Now, this offence of 498A, which was prescribed under 498A of IPC, now it is replaced by section 85, read with section 86B of Bharatiya Nyaya Sanhita 2023. According to section 498A Indian Penal Code, creating a new offence was created in 1983, the offence of cruelty, and it provides for punishment to the husband or relatives if they harass the woman with a view to coerce her to meet any unlawful demands of property or dowry. The punishment is the same in Bharatiya Nyaya Sanhita also. Dowry death, it is more effective or more strong provision in the Indian Penal Code in the form of the offence of dowry death, section 304B of IPC. Now, this section 304B of IPC is replaced by section 80 of Bharatiya Nyaya Sanhita 2023, and this section 80 of Bharatiya Nyaya Sanhita 2003 prescribed the punishment for a term minimum of 7 years and maximum of life imprisonment, similar to the punishment which was prescribed under 304B IPC. If we talk about the 304B IPC, dowry death is the death of a woman. What are the essential elements? Dowry death is the death of a woman if it is caused within 7 years of the marriage, number 1. Number 2, the cause of the death is not natural cause. If the death of a woman happens within 7 years from the date of the marriage, and number 2, if the cause of the death was not the natural cause, and number 3, if just before this death of the person, of the woman, there was any incidence of harassment or cruelty in connection with the demand of dowry, then such a death of woman would be considered to be dowry death. And for dowry death, the minimum punishment is the 7 years, and it may extend to the life. The Code of Criminal Procedure 1973 also provides for the secure post-mortem in case of suicide or death of a woman within 7 years of his marriage. It is the duty of the police officer of the concerned area, police station, under section 174 of CRPC. It is now replaced by section 194 of Bharatiya Nagarik Suraksha Sanhita 2023, and the punishment is, the procedure is provided that the post-mortem is to be secured by the police officer in charge of the police station. If the suicide or death of a woman is caused within the 7 years of her marriage. Then the Evidence Act 1872, section 113A. It has been introduced raising a presumption of cruelty against the husband or his relatives if the wife commits suicide within the period of 7 years from the date of her marriage. I told you that dowry death is the death which is caused within 7 years of the marriage, number 2, when it is caused because of the reason which is not natural, and number 3, that there was the cruelty or harassment of that woman in connection with the dowry just before the death. It is very difficult to prove the incidence of harassment or the cruelty just before the death of the woman, and therefore, section 113A was added to the CRPC to have the presumption of cruelty against the husband or his relatives if the wife commits suicide within a period of 7 years. So, if any suicide is committed by a woman within the 7 years of the marriage, then the harassment or the cruelty on the part of husband or relatives shall be presumed. It has been replaced by the and substituted by section 117 of Bharatiya Nagarik Suraksha Sanhita. Anti-dowry laws and further developments. The question of dowry deaths and the law reforms was suo motu taken by the Law Commission of India in its 91st report 1983. In Nathu versus State of Uttar Pradesh, which was decided in 2002, Honorable Justice Markandeya Karju observed that dowry death is worse than murder, but surprisingly there is no death penalty for it, whereas death penalty can be given for murder. In my opinion, the time has come when law be amended and death sentence should be permitted in cases of dowry death. So, the initiative on the part of Law Commission of India and this observation of Justice Markandeya Karju in the case of Nathu versus State of UP, who suggest the punishment of death for the offence of dowry death. Dowry death is worse than murder. He says that dowry death is worse. The justification for prescribing the death punishment for the offence of dowry death in accordance with the opinion of Justice Markandeya Karju is that dowry death is worse than the murder, and therefore, death punishment should be there. The Law Commission of India in its 202nd report, which was prepared by the Law Commission in 2007 on proposal to amend section 304B. This report of Law Commission of India says a case of dowry death also falls within the ambit of the offence of murder. Awarding death sentence is legally permissible without amending section 304B of IPC. So, the Law Commission of India goes one step forward by saying that even without the amendment of 304B, the death sentence can be awarded for the offence of dowry death, because the dowry death also falls within the ambit of the murder. What are the recent developments? Sabu, Stephen and others versus Union of India, this case was decided in 2021. The Supreme Court, some issues were raised by the petitioner before the Supreme Court. Pre-marriage courses, IIT BHU designs course on for brides to be. This course was designed for those girls, those women who are the prospective brides. Pre-marriage course. There should be a dowry provision officer at district level. This concern was also raised by the petitioner. No dowry certificate should be required for marriage certificate, and retain jewelry and property given to wife in her name for at least 7 years. Within 7 years, no dowry certificate should be required for marriage certificate. This should also be made the requirement. There was a bench of Justice D.Y. Chandrachud and A.S. Bopanna said that we are of the view that it may be appropriate if the Law Commission of India considers the issue in all its perspective. So, these concerns raised in 2021, this is the recent development, and the initiatives on the part of Law Commission of India, this is also the recent development. The petitioners were asked to submit their demands to the Law Commission of India, because the Supreme Court was of the view that this is the matter to be tackled with the legislature effectively, because this matter lies within the exclusive domain of the legislature, being the matter of legislative policy. And any matter of legislative policy is the essential legislative matter, or it is the matter of relating to the essential functions or essential legislative functions of the legislature. The court cannot intervene in these matters, and therefore, such demands may be raised before the Law Commission of India, so that the Law Commission of India may suggest the legislature to make the possible amendments in the law. Friends, if we see the Indian legal regime on the point of dowry or on the offence of dowry, then it seems that there are sufficient legal provisions, there are sufficient legal initiatives on the part of the legislature made in India, but there is a need to make these provisions effective in real sense. The second aspect of dowry, the offence of dowry, is that this is a social problem, and it cannot be tackled with, it cannot be dealt with, it cannot be eradicated only by the legal actions, only by making the laws and enforcing the laws. The change of the mindset of the society is also relevant with regard to the eradication of the offence of dowry in our country, and therefore, the proper awareness, the proper education is required in this regard. We also know that the boys and girls, or the brides and bridegrooms who are educated and they make the decision on their own part with regard to their marriage, such incidents are not happening. These incidences are happening where the marriages are set, the marriages are finalized by the parents or by the families of the brides and bridegrooms. Therefore, it may also be a valuable suggestion to the families, to the societies, that the parties to the marriage, that is the brides and bridegrooms, should also be included at the time of taking the decisions with regard to their marriage, and this is the fundamental duty of the citizens of the country to renounce every such practice which is derogatory to the dignity of women, and certainly the dowry is the practice which is derogatory to the dignity of women, and it deprives the women from their right to life and personal liberty. It deprives the women from their right to live with human dignity, and therefore, the citizens are also required to perform their fundamental duty and to save and protect women from this social menace, from this social evil and this offence of dowry. Thank you very much.
Hello, good morning everybody. I am Raghunandan Sengupta. So, I will just give you a very brief excitement area of finance, which is quantitative finance, and that has a huge market starting around about 10 years back, and it is exploding exponentially. So, what do we mean by quantitative finance? Quantitative finance is actually the application of different mathematical and statistical techniques in the area of financial markets, be it say for example derivative pricing, be it in the area of say for example portfolio management, be it in the area of asset liability management, be it in the area of portfolio management. We see that the application has exploded in such a way that there is a huge opportunity for people who have a quantitative background in mathematics and statistics. They can utilize those in the area of finance, but obviously with some prior knowledge of finance as a subject. Now, when we say about quantitative finance, as I said, it is an area of applied mathematics and statistics applied in financial markets. Use of different areas, if somebody is interested to know, we have stochastic calculus, we have derivative pricing, we have operation research, we have quantitative techniques like differential equations, stochastic calculus, time series, and they are heavily used in the area of quantitative finance as I mentioned. Now, we all know that in 1997 the Nobel Prize in Economics, so it is basically the Nobel Memorial Prize in Economics was given to the work of Merton and Scholz in the area of derivative pricing, and after that there has been exponential increase in the area of quantitative techniques in quantitative finance and in the area of different type of derivative pricing. With the advent, moreover with the advent of high ended and sophisticated computing data, big data has come in a very big way, where application areas starting from computing, from different type of algorithm design have been taken up in such a big way that nowadays at least we are able to understand that how high frequency data algorithm trading can be utilized using the concept of quantitative finance in the area of finance as such. But there is a flip side also, obviously when there is a huge amount of development. So, obviously due to some regulation errors or something, there has been some pitfalls, which I think is should be a bullet point for people who are really interested to take up quantitative finance. They should be aware. So, consider the financial crisis in 2008 and later on, and we are seeing different banks are failing, different financial institutions are facing a problem, countries are facing a problem like in Europe, in USA. So, what should be done? So, the main thing is that even if you know the technique, is best for people who are investors, who are private players, organizations like banks, governments should use these techniques in a very somber manner, such that the application areas of quantitative finance using the techniques which we learned can be utilized in the best possible way to garner the overall the in depth knowledge a person has in trying to utilize these quantitative techniques in finance. And I am sure that people who have the background, who have the knowledge, who have the sophistication, who have the knowledge of the society can definitely use quantitative finance in a very big way in trying to make their mark in this exciting field, which you are going to see in years to come. And I am sure it will be a very exciting learning tool for all the participants who will take quantitative finance as a subject in years to come. Thank you, and I wish all the participants all the best and best of luck for the programs they will take. Thank you.